Swayam Prabha. Digital India. Educated India.
Hello all. In this module, we are going to discuss about the IP licensing and the European Union competition rules. In this module, basically we will be dealing with the technology transfer agreements and the technology transfer block exemption regulation, which is in place in the European Union, which governs the various technology transfer agreements, or you may say which does the assessment of this various technology transfer agreement dealing with intellectual property right. Also, we would discuss the different steps of analysis where the IP licensing regulations are assessed for their probable violation of the competition law. And third, we will deal about the assessment outside the scope of this TTBER. As we have already discussed in the earlier modules that intellectual property rights gives a monopolistic right to the owner. So, by which unilaterally the owner is able to control his rights or control his innovations from the exploitation by the others. So, as it sounds directly opposite to the main principle of European competition law, which basically tries to maintain a uniform competition in the European market. But still, when we talk about the various agreements which deals with the intellectual property, particularly in the European regulation, these dealings or these agreements involving intellectual property rights are governed by basically two sets of regulation. First is the various rules and regulation of the European competition law, particularly the Article 101 and Article 102 of the Treaty of Functioning of European Union, which we have already discussed in length in the earlier modules. As we know, Article 101 basically prohibits various anti-competitive agreements, and Article 102 in particular restricts the abuse of dominant position. And since the IPR is a kind of monopolistic right, so it is necessary, it becomes sometimes necessary to place certain restrictions so that the IPR owner can get maximum benefit out of his innovation. But sometimes these restrictions may lead to anti-competitive behavior. So, these competition rules take care whether the agreement is per se falling under the European competition rules or not. And secondly, there are certain rules for the free movement of the goods, particularly the Article 34 to 36 of the Treaty of Functioning of European Union is regarding this, which governs the free movement of the goods. And particularly these two articles prevents the undue restriction to the cross border trades, and particularly Article 36 allows the member states to enact legislation regarding the intellectual property right. Obviously, it is guided by the principle of free movement of the goods, and also the exhaustion principle related to IPR is also applicable to these rules. Means like once the property has been sold, or maybe the technology or the goods are sold by the intellectual property rights, the intellectual property right owner cannot per se restrict the movement or the selling of the secondary or that goods in the secondary market, maybe in the same member state or in the different member state. So, these are broadly the two sets of regulation which deals with the or which regulates the agreements or agreements related to intellectual property right within the European Union. And so whenever intellectual property rights are associated, we talk about licensing, exclusive licensing agreement or licensing agreement dealing with intellectual property, particularly patents or utility models or software copyright, etc. So in those cases, the European Union or European Commission has adopted certain guidelines and also certain rules for assessment of this technology transfer agreement. And these guidelines are known as the block exemption regulation for technology transfer agreement, or TTBER. And the latest the revised version of this TTBER has come into force on 1st of May 2014. Basically, these guidelines or these block exemptions are a particular safe harbor or safe zone for the firms or companies who are involved in the technology transfer agreements. So, they have laid down certain standards. So, if the agreements are falling within those specified blocks, then it is per se conceived to be free from anti-competitive practices. But again, if it is not falling or not meeting the criteria laid down in the TTBR, then again assessment can be made to judge whether these are whether these are competitive or anti-competitive in nature. So, in order to simplify the assessment of the agreements, the Commission has defined certain categories of the agreements that are unproblematic from a competition point of view, based on its market and case experience. So, and these are set out in the various block exemption regulation or BER. So, if an agreement fulfills all the criteria in the block exemption regulation, it is exempted from the prohibition under Article 101 of the Treaty of Functioning of European Union. Basically, as Article 101 is all about the prevention of the anti-competitive practices, and when we talk about the various technology licensing agreement, it is basically agreement between a licensor and a licensee, agreements between two parties, where one party is giving the license to the second party. So, in majority of the cases, it may be in the form of the exclusive licensing or other maybe in different forms also. So, basically the first, like if there is any agreement related to IP, so the concern regarding Article 101 is more comparative to Article 102. So, as I mentioned, the revised TTBR guideline has been in place since May 2014. So, earlier to that also there are TTBR guideline were in place by European Commission. So, even though the general structure and most of the provisions of both these both of the versions of this TTBR were same, there are certain changes in particular regarding the restriction of the passive sales to the territories reserved for the new licensee, grant back obligations for non-severable improvements, and termination rights provided for a non-exclusive licensing, which may challenge the validity of the licensed IP. We will discuss this little bit later of this section. So, going next, and there are certain challenges to this revised regulation, and the main challenges were in the form of the applicability of this block exemption regulation, and they have now defined certain hardcore restrictions, and also they have specified certain excluded restriction under the Article 5. So, before going into this technology transfer and TTBER, first let us understand what is a technology transfer agreement. So, as per the EU competition law, a technology transfer agreement is a licensing agreement where one party, means the licensor, authorizes another party, the licensee, to use the technology maybe in the form of patents, know-hows, software licensing or a combination of these for the production of the goods and services. So, so as I told you, this may be basically the technology licensing agreements are included, the technology licensing agreements includes utility models, patent rights, know-hows, software design or design rights. The other forms of the IPR like the trademark and the other related like plant variety protection or geographical indication are not considered under this TTBR unless and otherwise it is directly associated with the production of the goods or services in question in line with the technology. Basically, the technology transfer agreement covers the licensing agreements between the two parties, or means there may be a single like the person who is providing the license, that is the licensor, and one licensee. So, there may be more than one licensee, but generally the technology transfer agreements are between the two parties, which is otherwise known as the bilateral agreement, or it may involve several parties, which is known as the patent pools, means where at a place all the IPR owners they come together and share their IPRs, and they may cross license with each other. So, that is a mode there is involvement of more than one parties in those type of patent pooling. However, the TTBER covers only the bilateral agreements, and the guidelines mentions about the multi-party agreement in the form of the patent pool and how to assess those kind of technology transfer agreement, but the block exemptions are only specified for the bilateral agreements. And the technology transfer agreements may be concluded between competitors, means those companies who are providing similar kinds of goods or technologies, particularly those are involved in the horizontal agreements, and they basically in this type of competitors, they both are having similar type of technology and produce similar type of goods or services. And the technology transfer agreement may also happen between non-competitors. Non-competitors are those entity which are not having the similar kind of intellectual property, and they exist in the different strata of the supply chain. For example, a manufacturing company and a distributor company for the manufacturing goods. So, technology transfer agreement can happen between these two sets of the companies, and depending on the nature of this agreement, whether it is happening between a competitor company or a non-competitive company, the block exemptions regulations has been specified, and the safe harbors are defined according to the nature of the agreement. So, basically if we look into a technology transfer agreement, there are three major functions of a technology transfer agreement. First, it involves IPR, means it involves maybe a patent, maybe a utility model, a design right, a know-how or a trade secret, maybe a mixture of these various forms of this intellectual property, and it may not in general it does not involve the trademark or other related IPRs unless and otherwise it is directly associated with the manufacturing of the product in question, and it is different from the true assignment. So, what happens in the case of the true assignment? The patent owner or the intellectual property right owner assigns all of its rights to the second person to whom which the right has been given. So, and the original owner does not retain any liability or any responsibility for the IPR in question. Whereas, in case of the technology transfer agreement, in general the licensor retains certain power over his technology, and it may regulate the functioning of this IPR which he has given to the licensee. And the third important feature of a technology transfer agreement is it may bring cross fertilization of the ideas. That means, like if a licensee has taken certain technology from a licensor, it may happen in due course of practice, it may generate certain new ideas, and which may in turn, like he may think of licensing it to other parties, or the licensee may think to cross license it to the licensor himself. So, in case of a technology transfer agreement, the cross fertilization of the ideas are possible. So, these understanding of these nature of the technology transfer agreement is very essential before deciding whether these kind of technology transfer agreement involving intellectual property is falling within the purview of article 101 or article 102. So, basically if we look into the scope of this technology transfer block exemption regulation, so the TTBER applies to the licensing agreement between only two undertakings concerning a whole range of IPRs, of which most commons are patents, know-how and software copyright. So, it is only the bilateral agreements are covered under the scope of the TTBR, multilateral agreements or patent poolings are in general are not covered, and the assessment is outside the scope of the TTBR. And generally patents, know-hows and software copyrights are considered to be the main intellectual property which are in question. Trademarks and other forms of IPR is not are not under the scope of the TTR unless it is directly linked with the product or process in question. And it also applies to the assignment of the technology rights provided like the assignment of the technology rights can be considered only when the licensor retains part of the risk exploitation, means when the licensor has not given all the rights to the other party, then only it will consider the assignment of the technology rights. And the technology transfer in question must be for the purpose of the production of the goods or services. So, only when the technology is used for the production of the goods and services which will be going to the market, then only the block TTBER exemptions are covered. In general, for the R&D, the use of technology for R&D purpose or for supply agreements are not covered under the TTBER. So, if a technology is licensed or a technology is given for the mere research and development purpose for the development of another technology, it is outside the scope of the TTBER. And or if it is for only for the supply agreement or any other related form, then it is also outside the scope of TTBER. Only when the product or service as mentioned in the technology is being manufactured or produced, then only the TTBER exemption guideline can be applied. And this point I have already mentioned. So, the trademark only be trademark or other related IPRs can be concerned when to the extent that these provisions are directly related to the production and sale of the contract product. And multi-party agreements are excluded from the scope of this TTBER. Consequently, so the TTBER will not normally apply to the patent pool arrangements, but the guidelines sets out the guidance when such agreement could be assessed under this TTBER guideline, which we will discuss in the later section of this module. So, after the scope of this TTBER, now understand how the what are the other provisions in the TTBER. So, there is an important provision regarding the market share threshold. Unless and until the competitor companies are having certain percentage of share in the market, they will not be covered under this exemption. So, in order to benefit from the safe harbor provisions provided in the TTBER, the parties must satisfy certain the relevant market share threshold. So, as we have already discussed the relevant definition of the relevant market, relevant technology market and relevant product market. So, relevant technology market are those where the technology has been licensed, and the relevant product market are those places where the manufactured products are being sold. So, both the relevant technology market and relevant product market together makes the relevant market. So, before a company can benefit from the safe harbor as mentioned in the TTBER, it must satisfy the relevant market threshold. So, when the agreement is between two competitive companies, means those which are dealing in the same kind of product or the services, the TTBER will only apply if the parties combined market share is 20% or less on either the relevant product or the geographical market or on the relevant technology market. Means taken together, both these competitive companies should market share should be less than 20% or at best 20%. But when the technology licensing agreement is between two non-competitive companies, the TTBER will apply if the parties have a market share of 30% or less individually. So, either in the relevant product market or geographical product market. So, for the competitive companies it is 20% or less, and for the non-competitive companies, agreement between the non-competitive companies, it is 30% or less. So, it is very difficult to assess how much like the market share, because it is the parties, the company's responsibility to assess their relevant market share. So, one may question like how it has been decided, but again this is the provisions threshold as specified in the TTBR. Once the provisions of the safe harbor or TTBR has been applied to certain technology transfer agreement, it may possible that the company's market share may change. It may go to a higher side or go to a lower side. So, the TTBR also allows for a 2-year lag between a party exceeding the relevant market share threshold and the agreement losing the protection of the TTBR. Means 2 years lag period is given, within which if there is certain fluctuation, that is considered. So, a company's market share may wobble around the threshold, may be exceeding in 1 year, and again it may fall back to the normal in the next year without losing the benefit of the exemptions. So, these are the salient features in the TTBR regarding the market threshold under which the companies can enjoy the safe harbor. And as I mentioned earlier, so one of the in the revised TTBR guidelines, so the article 4 specified certain hardcore restriction technology. So, the transfer of agreements concerning the hardcore restriction will not benefit from the safe harbor provisions in the TTBR. Means if there are certain hardcore restriction in the technology licensing agreements, then the safe harbor provisions are not given to those kind of agreements. So, now let us understand what is the hardcore restriction. So, again the hardcore restrictions are also defined differently for the agreement between the competitive companies and the agreement between the non-competitive company. So, in relation to the agreements between the competitive company, the TTBR classifies the hardcore restrictions as: first, the price fixing or any other restriction of the party's ability to determine its price when selling to the third parties. Means if there are certain clauses that allows the licensor to define the price or fix the price, or may place any other restrictions where the licensee has to take the permission or has to take the consent from the licensor to fix the price when he wants to sell it to third parties, then it would be covered under the hardcore restriction. Second, if there is certain clauses regarding the limitations regarding how much a party may produce and sell. So, if in a agreement the licensor puts a clause that only this much amount can be produced or this much amount can be sold in the market, then it would also consider the hardcore restriction. Third, any restriction of the territories into which or the customers to which the licensee may sell the contracted goods or services. So, if the licensor specifies the geographical market or geographical location where the products may be sold, or he defines the list of customers to whom the licensee can sell the good, is also a kind of hardcore restriction. And the next one, any restrictions on the licensee's ability to exploit its own technology, or restrictions of either party's ability to carry out research and development, is also a kind of hardcore restriction, as we discussed earlier. So, it may possible a new kind of technology may be developed during the exploitation of the licensed technology. So, if the licensor places certain restriction by which the licensee is unable to benefit from his from the technology which he has developed in due course is also be considered as a hardcore restriction. So, if these kind of restrictions are in place in certain technology transfer agreement, then the TTBR does not allow them to be in the safe harbor provision. And coming to the agreement between the non-competitive company, the TTBR classifies the hardcore restriction into the following three kinds of restriction. First, again the price fixing, means other than imposing a maximum price or recommended retail price. So, he may recommend a retail price or the maximum price, but again price fixing is a kind of hardcore restriction. Any restriction of the territories into which the customer or to whom the licensee may sell the contracted goods or services, and any restriction on the active or passive sales to the end users by licensee which any members of a selective distributing system operating at the retail level or supply. So, these are the three kinds of restrictions similar to the restriction placed in the competitive agreement between the competitive companies. So, in case of agreements between the non-competitive companies, if certain any of these three kinds of restrictions are put, then it may also come under as a hardcore restriction. And again the article 5 of the TTBR specifies certain excluded restriction. So, those which we discussed about the hardcore restriction, now these are the excluded restriction, where means any obligation on the licensee to grant an exclusive license to the licensor or to a third party designated by the licensor in respect of its own improvement or its own new application of the licensed technology. So, the new technology which has developed in due course by the licensee, if the licensor regulates the transfer of those technology to himself or to a third party, it is one kind of a excluded restriction. And any obligation on a party not to challenge the validity of a IP rights which the other party holds in the European Union. So, what happens sometimes during the licensing agreement more than one technology is being transferred, and sometimes the validity of this, when there is a dispute between the licensing agreement, the licensee generally questions about the validity of those IP rights. So, why this? So, before placing this kind of technology transfer agreement, sometimes what happens, the licensor initially sets a clause so that the licensee cannot challenge the validity of the intellectual property right. So, these kind of restrictions are a kind of excluded restrictions. So, basically the TTBR provisions covers all these things. So, one more in that section was the in agreement between the non-competitors, restrictions on the licensing ability to exploit its own technology or restriction on the other party's ability to carry out research and development. So, sometimes even R&D clauses has been set, like what can be done or how this technology can be used or licensing technology can be used or not. So, these kind all this kind comes under the excluded technology. So, now the so far we knew that the TTBR like the scope of the TTBR and the minimum market threshold which a competitor which the competitive company or non-competitive company must retain in order to enjoy the safe harbor provisions, and the exception regarding the hardcore restrictions and also the excluded restrictions. So, basically this TTBR means the technology transfer block exemption regulation gives a safe harbor to the companies entering into a technology licensing agreements. So, if they meet the criteria as mentioned in these TTBR or the block exemptions, then they are free from any kind of scrutiny, because as the IP licensing involves two parties. So, they are entering into a kind of agreement, and the question regarding article 101 may come first, as it is all about the anti-competitive agreements. So, if they are falling under the safe harbor provisions, then the European Commission will not look into those kind of agreements in purview of this anti-competitive practices. However, if they do not satisfy, or if the market threshold is high, or if there are certain excluded restriction or hardcore restriction, then in those cases the European Commission may take separate assessment to determine whether their behavior are anti-competitive or not. So, basically in order to determine whether these kind of technology transfer agreements are falling under this TTBER exemption or not, the European Commission follows a 3-stage analysis. So, in these 3-stage analysis, first the European Commission looks into whether the parties to the agreement are competitors or not. So, as we discussed, so there are two kinds of competitors, like those who are in horizontal agreement, means dealing with the same type of product or the services, has similar kind of IPR. So, these are known as the competitor companies, and non-competitors are those which are a kind of in vertical agreements, means a manufacturer and a supplier. So, they do not have the access to the same kind of intellectual property right or same kind of technology. One needs the licensor to give certain technologies by which he can enter into the market, and within small period of time, that is the SS and NPI test, which we have already told, means by acquiring the license within 1 or 2 years, the new company wants to enter into the market, and if it has a substantial presence in the relevant market, then it will become a competitor after that. So, first stage of this analysis is to look that whether the parties to the agreement are competitors or not. If they are competitors, then the second stage would be for how much market share do the competitive company or the non-competitive hold. So, if they are competitor companies and if their shareholding is 20% or less individually, then if their shareholding is more 20% or less combined, then it is under the safe harbor provision. And if there are if the companies are non-competitive in nature, and then their shareholder should be less than 30% individually, so that they can enter into the safe harbor. But this is the second stage. One more stage of analysis is there, means whether the agreement contains any problem clause or not. Means suppose there are two competitive companies and combined share is less than 20%. So, they have now satisfied the two requirement. So, the third requirement which the European Commission would look is whether the technology transfer agreement contains any restriction or not. So, it may be a hardcore restriction or it may be a excluded restriction. So, if there is any hardcore restriction, suppose there is no hardcore restriction, then it will look into whether there is any excluded restriction or not. Then if it found that there is certain excluded restriction, then also there is a possibility that if they can remove those restrictions, so that it can be a normal technology licensing agreement. So, if that is possible, then it may possible that the competitive companies, the agreement between the competitive companies is under the TTBER or the safe harbor zone, and if not, then individual assessment has to be made. So, this is the 3-stage analysis which the European Commission and the national competition authorities do before judging whether the technology transfer agreement containing or involving an element of intellectual property right can be provided a safe harbor in the European member states or not. So, apart from this, there are certain assessment criteria for the agreements falling outside the block exemption regulation. So, basically in this like if a competition, if a agreement falls under the falls out of this block exemption regulation, it does not necessarily mean that it is anti-competitive. So, individual assessment is made. So, if it is not anti-competitive, then well, there is no problem, but suppose there are certain elements which seems to be anti-competitive, then individual assessments are also made. And also it can be justified on the basis that because of this kind of restriction or the agreement, it has improved the production or the distribution of the goods or services and has promoted the technical economical progress in the European member state, and it has provided a consumer a fair share of the resulting benefit, and the restriction which it contained are indispensable to the achievement of the benefits. or it has not allowed substantial elimination of the competition in the market concern. So, if those points can be justified, it may not be considered as the anti-competitive. There are some more agreements which we will discuss, by the settlement agreements, the patent pooling cases and pay for delay cases. So, which we will be discussing in the next module. Thank you.